Hello, my name is Tina Hylands. I work for the Edenbridge branch of Parfitt Cresswell, Jevons, Riley and Pope. I've been asked to provide you with a brief presentation setting out the requirements for a divorce. The first requirement is that you need to have been married for a minimum of 12 months. It used to be 3 years, but it's since been reduced to 1 year. So therefore, that's the requirement nowadays. You need to be married for 1 year. The only ground for divorce is irretrievable breakdown of marriage. That means that you need to be satisfied that there is no way that you could possibly continue to live the rest of your life with your spouse. So, as I say, that's the only ground for divorce. But that does need to be supported by one of 5 facts. And just to run through those quickly, they are adultery, unreasonable behaviour, desertion for 2 years, 2 years separation with consent, or 5 years separation. So just to give you a bit more information on each of those, adultery is where your spouse has formed a relationship with another person and has had intercourse with them. It can be a one-night stand, it doesn't have to be a full-blown relationship, but it is necessary for you to find it intolerable to continue to live with your spouse as a result of that adultery. You need to have both of those aspects in order to petition on that basis. The second fact is unreasonable behaviour, and that's probably the most widely used fact currently. In fact, I would have said for some time. So if your spouse has acted unreasonably towards you during the course of the marriage, then you would be able to petition on this basis. I do have clients who tend to come into the office with reams of unreasonable behaviour allegations, setting out all the horrible things that have happened to them during the course of the marriage, but it's not actually necessary nowadays to use that much detail. So we at Parfitt Cresswell are trained by resolution, and therefore we need to try to keep the animosity between the parties as low as possible, and therefore we make the allegations when we draft a petition under unreasonable behaviour. We will ensure that the allegations that are contained in the petition are necessary. Obviously some unpleasant things need to be said about the respondent, otherwise the judge is not going to consider the petition sufficient to grant a decree under English law. So it's a line to be trodden, and obviously it's one that we could help you with if you needed some guidance. Desertion for 2 years is a very rare fact that not used very often at all. In fact, I've been in practice for 30 years and I've never divorced a client on that basis, and I don't actually know any colleagues who have either. It's where one party leaves the other and goes off, and the petitioning party has no idea where they are, and more than 2 years have passed. So that's that ground, that fact, but as I say, not a very common fact at all. The fourth fact is 2 years separation with consent. This is often used because it's obviously a non-controversial ground, and it is possible to have to be separated whilst you're living under the same roof. Obviously, with finances being the way they are, sometimes it simply isn't possible to achieve physical separation. But providing you do have completely separate households whilst you're living under the same roof, then it is possible to incorporate that time as separation. But obviously you shouldn't be washing the other party's clothes or cooking for them or cleaning for them. All of those matters should be completely separated, and as far as possible finances should be separated too. And the final fact, I beg your pardon, we need to have consent. Sorry, going back to 2 years separation. With 5 years separation you don't need consent, but with 2 years separation you do need consent. So if you're separated for 2 years, the respondent, that's the party against whom the petition has been issued, they will need to give their consent to that petition. It can either be done by them confirming their consent on the acknowledgement of service that they send back to the court, or they can sign a confession statement. Whichever works for them is absolutely fine, but you do need to produce evidence of their consent to the court for 2-year separation to be successful. But then we move on to 5-year separation, and we don't actually need consent there. If the parties have been separated for a period of 5 years, then that is a fact in itself that the court will accept as being a basis on which a decree can be granted. So I hope you find that helpful. That gives you the basic requirements for a divorce, and if there's anything that we at Parfitt Cresswell can do to assist you in relation to such matters, then we'd be very pleased to. Thank you for listening.